Something happened in the lawsuit? No, not really. I just haven't gone over anything in a while. They filed for basically a continuance, I think, on the case. They wanted the trial to be pushed back 2 months. A couple days after that, the judge set a hearing on it. We both filed our motions in limine, which is just stuff that we're saying should be able to, stuff that we should be able to exclude at trial. I think we argued that the Roe stuff wasn't relevant anymore. We try to argue that Abby stuff shouldn't be submitted since we haven't gotten the chance to, there's no probative value. We don't have the originals. It's all been redacted. There might have been one other thing. I don't remember. And then I think in their motions in limine, they tried to basically exclude every single broad argument that we could use for our case. It's based. Judge also denied their order for a gag order, which was good. Weren't you hoping or expecting a dismissal? We're always hoping or expecting a dismissal. The hearing in 3 or 4 days is hopefully we get good memes. I'm hoping since the judge called a hearing on that order, because I would have expected that order to have been automatically granted, and it absolutely was not granted automatically. The judge called a hearing on it immediately, so I'm hoping at that hearing we're going to address the subject matter deposition stuff. And I don't think they have anything for it. They just don't have anything. So I'm hoping the judges will say this is retarded and boot it. But I mean, who knows? Do you think Melina is going to give a deposition? There's no shot. I don't even know if they want one from her. The thing is that Pxie was talking to Melina at the beginning of this court case when Pxie was like, "Oh, don't worry. Like, I'm going to get him. He's going to go to jail. He's going to get arrested. He's going to be on the sex offender list." But then, so she was talking to her in the beginning, and now they're trying to say they need to subpoena Melina in order to depose her. It sounds like Melina has no interest in being a part of whatever the Pxie's doing. Although I don't know what their communication is like, because again, I don't have any messages, or I got like 4 messages between Pxie and Melina, not that many though, but I don't have any full conversations, but it sounds like their communications broke down. But I mean, like, one, Melina wouldn't have anything relevant at all, so I don't even know what she could possibly be deposed to of, number one. Number two, I don't even know if I ever sent Melina any of this, but if I did, this would have been back in like when we recorded it in 2020. So it also would have been out of statute range. And then that's 2. 3 would be even by Pxie's own admission. Well, it depends on what statement you take at face value. She said that I had permission to share things with Melina, so that wouldn't matter. And then 4, Melina and I were married, and Melina can invoke married privilege there, so she shouldn't even have to testify to anything in this. 5, if they really wanted to depose her, after they get approval from the international court, they would have to retain a lawyer in Sweden to do the deposition, and then to file, like, it would just be such a cluster. I don't know. Destiny, are you on bad enough terms with her that you'd ever expect her to want to participate? No, I mean, I don't think she cares. I don't. There's nothing she can testify to that would hurt me, but I don't know if I just think they're just trying to do it to drag out the case and to make it waste time and to attack as many people around me as possible. Won't the judge be able to easily tell this is just a fishing expedition? It seemed fairly obvious by the lack of any evidence. I mean, I don't know. I would hope so, but one of the issues is we're so close to trial that I don't know if the judge will just say, let's fucking run it, because we're so close anyway. But I don't think that'll happen because I don't think we can go to trial in this state. We have to do party depositions. So, and they skipped their deposition. The big thing, like there's so many weird things about this case. So one is that, like, we can't really go to trial, I don't think, without doing party depositions. That seems kind of crazy. But they skipped their deposition for no reason. Like, we filed it, we noticed it with the court, and then they emailed my legal team, and they're like, we're not going to this. And then Andrew's like, okay, well, if you don't want to go to your deposition, then file it with the court. And they were like, we're not going to bother filing with the court because this is bullshit. We don't have to go. And so they just skipped it. And then the judge issued a show cause immediately after saying, why the did you skip a deposition that was noticed with the court for no reason? And they were like, well, we shouldn't have had to go. My guess is I'll be sanctioned for that. But it's going to be, I imagine it would be hard to argue that, like, we need to open discovery because we need to do party depositions when we skipped ours for literally no reason, because they didn't even put the court on notice. I have no clue. I don't know how lenient the judge is and shit like this. It's federal court, so it should be like a little bit more serious. So who knows? Subscribe now. Is there any logical reason for them to avoid the deposition? Is there something to hide? Is she avoiding something? Steelman this. I don't know why they skipped it. I don't know why they didn't notice the court. They should have told the court they should have told the court that they were going to. There's no reason for them not to do that. That's just a mistake on their part. That's why the judge issued a show cause. Show cause means you have to show a good cause for why you didn't do something. Otherwise, you're going to get sanctioned or penalized or something. I have no idea what the fuck they could possibly say to that. You said talking with Kafka that you had a notion that your team didn't believe you, at least initially. Could you elaborate? I mean, I don't know 100%. My guess is I've heard it said a lot that clients lie a lot to their legal team. And they were just the way that they were so cautious about everything in the beginning. My guess is that they thought that most of Pxie's original complaint was probably true. It's probably pretty exceptional that somebody would lie about 90% of what you would put in a lawsuit, at least a high profile lawsuit maybe. So they probably thought that like I probably f***ed up considerably more than I was telling them, which is fair. I imagine a lot of, maybe that's just my assumption, but maybe they don't. I don't know. Maybe they don't think that. But can you read their opposition to your lemony? I don't know if they filed it yet. Did they? Defendant's omnibus motion in limine is not a proper evidentiary motion. It is an attempt to resolve disputed facts, relitigate issues, and exclude probative evidence through procedural shortcuts. The motion repeatedly seeks exclusion, not because the evidence is inadmissible, but because defendant disputes it or failed to develop it in discovery. God, this reads like AI. This is blah, 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 blah. Not because of this, but because of the, I don't know. I feel like halfway through this case, Jones started to switch to AI, especially when they said they use Lexis. They said they couldn't find one of our cases on Lexis, so they said it didn't exist. I feel like actually all the law things online, Westlaw, all have their own AI things now, but I'm pretty sure, I'm almost positive Jones is using AI to write these briefs now because the writing significantly changed like halfway through this case. But whatever. Defendant first seeks to exclude evidence relating to his transmission of sexually explicit material to a minor based on a contested factual narrative. But such disputes are for the jury, not a basis for pretrial exclusion. First of all, so again, it's out of date range for the statute that they're trying to sue me under. So you just can't include it. It's not in the date range. I'm sorry. I know that makes you mad, but you can't typically sue people for crimes that didn't exist before or that didn't exist before a bill was passed that made it a crime. But they want to, they really want the pedo jacketing shit in here. They really want the minor. She was a minor. Child minor. He next attempts to exclude testimony and evidence from a non-party witness, AbbyMC, despite having known of the witness, communicated with her, and served a subpoena, yet choosing not to enforce it. I think we managed to serve the subpoena like weeks from the closure of discovery after they hid her from us for a year, and obviously she didn't respond to it at all. What does the minor narrative do to help their filing? Nothing. Whether or not the girl was 16 or 5 years old or 1 year old or 500 years old, it has absolutely no bearing on the Cardi statute. It has no bearing on any part of this lawsuit whatsoever. I don't think it goes to proving any of the elements of anything, of any part of it. It's none of it. Yeah, it's just, they just want to include it to fuck with me, basically. Defendant cannot manufacture prejudice through his own lack of diligence. Defendant also challenges the admissibility of the AbbyMC exhibit on grounds not raised during the required meet and confer process and that fail on the merits. Finally, he seeks to strip plaintiff of pseudonym protections already granted by this court, despite binding 11th Circuit authority permitting anonymity through a trial where, as here, substantial privacy interests outweigh any alleged prejudice. At bottom, defendant's motion is an effort to exclude damaging but admissible evidence and to revisit issues already decided. Because defendant identifies no valid basis for exclusion, the motion should be denied in its entirety. Defendant seeks to exclude any reference to Rose's status as a minor. This argument rests entirely on a disputed factual premise. The defendant never communicated with or transmitted materials to a minor because a third party allegedly controlled the account. And it fails for multiple independent reasons. One, defendant failed to confer on this issue before seeking relief. I don't even know what this means. We literally put them on notice for errata or whatever, and then gave them 21 days to amend their filings, and then we have outstanding Rule 11 sanctions against them related to this issue. So I don't know how they say we haven't brought it up, but okay. I don't know what that means. The evidence is not false, but disputed. Really? We're going to go to court and we're going to argue the catfishing narrative without either of us having any deposition or anything related to Solo or the person control? Really? That's what we're disputing at court? Really? Stupid. Destiny, you didn't know if it was or wasn't a crime at the time. It's not like you changed your behavior once. It doesn't matter you can't sue people for things that weren't laws yet in the past. You can't do that. It just doesn't work. It doesn't work that way. Sorry. That's how most systems of law work. Why is that even relevant? This is not relevant. It's just her trying to f with me in the lawsuit, basically. 3, it is relevant. And 4, it is not excludable under the rules of evidence. First, defendant's argument should be rejected for failure to comply with local rule 71A3's meet and confer requirements. During conferral, defendant stated only that he intended to seek exclusion of evidence relating to alleged transmissions to Rose on the ground that such conduct predated the Carty statute and was therefore irrelevant. He did not raise, let alone meaningfully confer on, the distinct argument advanced in this motion pertaining to Rose's age. Failure to confer or to show a good faith attempt to confer by itself constitutes grounds for the motion to be denied. Second, the record demonstrates that the factual premise underlying defendant's motion is hotly disputed and cannot be resolved through a motion in limine. Defendant's motion, as well as his related Rule 11 motion, conveniently omit that Rose testified that Solo shared with her the materials Bonnell sent to Rose through the Discord account. During her deposition, Rose admitting that she was shown a handful of videos that Destiny sent via the imposter account. Rose also testified that Solo shared with her the Discord messages exchanged with Bonnell, and that she knew that the explicit images and videos that she took of herself and with other individuals would be provided to Bonnell. Thus, the facts demonstrate that Bonnell intended to send the video to Rose, a minor, that he sent the video and other sexually explicit videos to an account in her name, and that Rose received at least a handful of those videos, including possibly the video. Good one. King arguments. Based on these facts, the assertion that Bonnell shared the video with an underage girl is not false. Simply put, the fact that Solo acted as a go-between or controlled Rose's account does not render the assertion that Bonnell shared the video with a minor false. Rose further testified that she does not know the plaintiff. This is important because if Rose does not know the plaintiff, she could not know any way or another whether one of the handful of videos that Destiny sent depicted plaintiff. Okay. You know what? It sounds like they really should have tried to sue the Solo guy. Almost like that would have been a way better court case. Third, defendant's catfishing theory does not render the evidence irrelevant. Even accepting defendant's characterization for purposes of argument, the evidence remains probative of 1, defendant's knowledge, intent, and absence of mistake in engaging in sexually explicit exchanges, 2, the nature and scope of his online conduct, and 3, the foreseeability and risk inherent in disseminating intimate material in anonymous online environments. Courts routinely admit such evidence for these non-propensity purposes, blah, blah, blah. Okay. This is also where plaintiff's own motion in limine to exclude the catfishing defense is fully consistent, not contradictory. Plaintiff's position is not that the factual circumstances surrounding Rose's Discord account are irrelevant. Rather, it is that defendant should be precluded from using an unsubstantiated catfishing narrative as an affirmative defense to avoid liability. This is such a weird... I don't even know why they're... I don't know. Even if the court permits defendant to present that theory, it does not follow that plaintiff must be precluded from introducing the underlying evidence, including Rose's minority, that gives context to those same events. In other words, defendant cannot simultaneously rely on the circumstances of the exchange while shielding the jury from a probative and consequential aspect of those circumstances. Furthermore, defendant's own framing confirms relevance. His Rule 11 motion repeatedly acknowledges that the dispute centers on whether he exchanged sexually explicit material with a minor and whether the allegation is false or irrelevant. That is not an argument for exclusion. It is an argument on the merits. Yeah, but none of the merits of the elements of the crimes that you are suing me for. It's not, merits don't just mean any random fact that you want to dispute in the record. And as plaintiff has already demonstrated, Rule 11 cannot be used to resolve disputed factual issues or to strike evidence simply because defendant contests plaintiff's interpretation of it. Fourth, Rule 403 does not support exclusion. Defendant's argument is premised on the notion that reference to Rose's age is inherently prejudicial, but the 11th Circuit makes clear that Rule 403 excludes only unfair prejudice, not evidence that is merely damaging. Here, any prejudice flows directly from the probative force of the evidence, namely the defendant engaged in conduct involving an individual who was, in fact, under 18 at the relevant time. And by involving an individual engaged in conduct, we mean engaged in conduct with a catfish go-between who was misrepresenting the person's age, but okay. That is not a proper basis for exclusion. To the extent the court has any concern, it can be addressed through a limiting instruction rather than wholesale exclusion. It is well settled that a curative instruction ordinarily resolves any concerns of prejudice. For these reasons, defendant's request to exclude all evidence relating to Rose's age should be denied. Defendant cannot exclude AbbyMC evidence based on his own failure to pursue discovery or a non-party's alleged non-compliance with a subpoena. Defendant seeks to exclude evidence relating to AbbyMC on the grounds that plaintiff's counsel allegedly obstructed his ability to obtain discovery, and that the witness failed to comply with the subpoena. These arguments provide no valid basis for exclusion. First, the underlying factual assertions are incorrect. Second, the governing law does not support the requested relief. The relevant facts are straightforward. AbbyMC is a non-party witness, not under plaintiff's control. By the way, when I don't know if they forgot this or if they're just lying, but the very first email that I got from them was them claiming that they were representing Abby and that she was going to sue me for $500,000 as well. But okay, I guess we're just forgetting that ever happened. Well, I don't understand this argument. I understand that you're just a gesticular or somebody retarded or whatever, but at Destiny, it makes a little sense when the FBI pretends to be a child to catch someone. It's not like you say, nah, the FBI agent was not a child, kind of. No, what? When the FBI is posing to catch somebody, they're posing as a minor. You don't pose as an adult. That's retarded. It's completely backwards. Is that email something that is part of evidence for the case? I don't know if that... I think Andrew brings it up, I think, in something. Abby has never been represented by plaintiff's counsel in this matter. Okay. Plaintiff did not obstruct defendant's access to AbbyMC. Defendant observed AbbyMC with a subpoena duces tecum, approximately 1 month before the discovery deadline. And defendant failed to move to compel, seek contempt, or otherwise enforce the subpoena. Having failed to pursue available enforcement mechanisms, defendant can now rely on his own lack of diligence as a basis to exclude otherwise admissible evidence or to claim prejudice. Why would you not want to depose your own witness? Would you not want to do that? Am I crazy? This is the witness for the prosecution. Why would you not want to? Why would you not want to depose them? No, I don't know. Especially when this is your only evidence for the entire case. First, the assertion that plaintiff's counsel. Oh, I'm retarded actually. Why would they not want to depose him? They don't have to depose him, I guess. They can just ask him all the questions they want privately and then figure out how they want to play it going to court. Could you have moved to compel Abby? I don't think we had enough time before discovery closed to do it, because we finally got her, served her. I think it was within a month of closure of discovery. This was not a non-party witness unknown to the defendant. The defendant had an intimate relationship with AbbyMC commencing in early May 2023 and had ongoing communication with her well after the initiation of the suit, and at least as recently as May 2025. Not where I had her address or phone number or like where she could be served, but okay. Indeed, defendant knew AbbyMC for years before the plaintiff did. Plaintiff's counsel provided AbbyMC's contact information as it became available to them, which is all that federal rules of civil procedure requires. I'm curious how the judge is going to treat this, because this is like obvious game playing. You're telling me that you were able to solicit a affidavit, a declaration from this person, and evidence from this person, but you weren't available to make them available, or you weren't able to make them available to the defense at all, or to depose them at all, or to have any information about their address or anything at all? I don't know. Indeed, AbbyMC was apparently homeless for an extended period of time, and thus there was no address to provide. And contrary to defendant's false claim, plaintiff never provided a fake address for AbbyMC. Defendant's assertion that plaintiff's counsel refused to accept service of the subpoena on behalf of their client is also false. Plaintiff's counsel expressly advised that they did not represent AbbyMC for purposes of service and were not authorized to accept a subpoena on her behalf. Defendant is falsely characterizing AbbyMC as a client. How much you want to bet that if discovery does get pushed back and we are able to depose Abby, that all of a sudden Abby is going to end up represented by Joan? Destiny, I think through whatever means, probably your stalker, some people are not aware of the fact that the person behind Rose's username introduced themselves to you as a female over the age of 18. The person who, the solo guy, whoever the fuck was the George guy, I guess, who was controlling Rose's account, when they first contacted me, they said they were 18 or over. They never presented themselves as a minor. But there's so much stupid information flying around about this case. This is why I just need a judgment in hand before I can write up everything and do my going over everything. The undisputed fact is that the defendant successfully served AbbyMC with the subpoena duces tecum on November 21st, 2025, almost a full month before the discovery deadline. I think discovery closed December 15th? Additionally, defendant aggressively objected to plaintiff's motion to extend the discovery deadline, thereby choosing to foreclose any further opportunity to pursue a subpoena response. Nor did defendant ever attempt to subpoena AbbyMC for a deposition. Having failed to enforce his own subpoena, defendant cannot now seek the extraordinary sanction of excluding admissible evidence or shift the consequence of his lack of diligence onto plaintiff. Nice. I haven't read any of these underlying cases. I do like that when the judge wrote when he denied the gag order that they were seeking, the judge did go, well, I guess the judges have to, and their clerks whatever, went through all the cases and were like, basically every case you're citing here is fucking retarded, which was pretty funny. Even setting that procedural failure aside, defendant's motion fails on the merits. First, the exhibit is properly authenticated. The 11th Circuit makes clear that the burden to authenticate evidence is not high and requires only a prima facie showing that the evidence is what it purports to be. But all of my evidence is not enough. By the way, the only evidence they have is fucking blurred out, I guess, a Discord message that I don't even know it's who. I never even got the unredacted version of this message. I have no fucking idea. I still don't have this. I still don't even know what this message is. 10 months after it was submitted, I believe literally one day before our evidentiary hearing, to try to escape the, because they knew that they didn't have any evidence for subject matter jurisdiction. No shot. It really was the night before. Does it tell you what time a thing was submitted? Can I see that? Actually, so fucking wild to me. The day before we have our hearing on the preliminary injunction, they fucking throw in their only witness. After supposedly having 15 plus women all ready to come forward, they throw in their only fucking witness the day before the hearing. So fucking stupid. What a joke. Filed at 5:26 p.m. Filed in the evening of the 2nd. This would have been 17 hours, I think, before our 17 hours before our preliminary injunction hearing. Like, actual joke. And then this is the whole, all the evidence that keeps this court case alive hinges on whatever these messages are. By the way, Destiny sends me sex tapes all the time. I have videos of him fucking Cherry and Pxie Limfao. He just sent me another one. Supposedly, this is me sending her videos of Pxie. But I went back and I checked my logs. I haven't sent this chick anything of Pxie. I don't even know what these messages are. I don't know who they're to. I don't know what the context is. And then during the hearing at the preliminary injunction, we asked them, like, did Abby even show you proof of him sending any videos to her of you? And she said no. So I don't even know what I have no clue what this message is. I don't know what this is. But their whole case, the entire case that they have right now, all of it is contingent on this one Discord message that they swear to God is definitely true and real, that I don't even have an unredacted version of. Ah, oh, Jesus Christ. Absolutely fucking based. Pure cinema. Not only was it 17 hours beforehand, it was after business hours in the hopes that your attorneys wouldn't see it until the day of the hearing at best. Yeah, I guess. Yeah, it was just it's just wild. What are you going to do? What are you going to do? Here, AbbyMC attested under penalty of perjury that she personally sent the message reflected in the exhibit and retained copies of those communications. Her declaration further describes the same contemporaneous communication to a friend regarding defendant's transmission of sexually explicit videos on or about November 3rd, 2023. The AbbyMC exhibit corresponds directly to that testimony. I don't even know what this would be. Is this... If you're citing your own chat logs, do your chat logs count as hearsay of your own stuff or not? I don't know how it would work here, but... Defendant incorrectly assumes the message is offered solely for the truth of the matter asserted. It is independently admissible to corroborate AbbyMC's sworn testimony. The defendant transmitted sexually explicit material to her. At minimum, the statement qualifies as a prior, consistent statement to rebut defendant's insinuation of fabrication. I guess. This is probably why they didn't want her to be deposed, because if she was deposed, everything would be destroyed on her side. That last exhibit would fall apart, and then, yeah. Whatever. Oh, we're trying to get her pseudonym stripped as well. I want this case attached to her name as much as possible. Defendant's request to prohibit plaintiff from proceeding under a pseudonym at trial should be denied. The court has already granted plaintiff leave to proceed anonymously upon a finding of good cause. The defendant offers no basis to revisit that ruling, let alone satisfy the demanding standard required to strip those protections at the eve of trial. Defendant has repeatedly used his online platform to publicize this case, disclose sensitive information, and target plaintiff, her counsel, me, and witnesses. Witnesses have expressed fear of retaliation and reluctance to participate, absent confidentiality protections, which they have. And defendant has publicly disclosed plaintiff's identity, despite court-ordered protections. I said her first name, I think, on the very first day of the case. But also, when she opened her Give Send Go, it literally had her whole identity was literally attached to it. But okay, chief. Oh. Defendant further attempts to claim prejudice by asserting a plaintiff accused him of despicable conduct and breaking the law, destroying his reputation of the process. Defendant's argument collapses under its own premise. Plaintiff is the victim, and defendant has admitted to his despicable conduct, which is a violation of the law. Thus, he destroyed his own reputation. Fuck, did I admit? Well, fuck. We should just have this up front, and we can be over with it. I'm pre-guilty. Yes. This is also retarded, too. Plaintiff has consistently sought to protect her identity and in the limited instances she has posted on social media, has done so under the screen name Pxie, not her legal name, okay? Nobody knows who Pxie is. I wonder if it ever got to trial and we had to argue and somehow I lost and we had to argue damages or something. I wonder if I could just argue. It's like, oh, well, don't worry. There's no harm to you because nobody even knows who you are. It's just Pxie, right? Jesus Christ. That's crazy, chat. True. Sometimes shit do be crazy. What are you gonna do?